Well, we'll discuss the meeting with the chief and other business at the end of the agenda. Next, I guess we'll just move on to investigation recommendations. We have quite a few of them. We had some carried over from last month, and then some from this month as well. So I will start with 180 IG-2025. The date of the incident is November 21st of 2025. And we received the complaint 2 days later. The complainant states when an officer pulled her over for running a stop sign, he was rude and was not clear with his direction on how to handle the ticket. In this matter, we were able to review the body-worn camera, and we are recommending no further investigation. The officer dash cam shows that the complainant did run the stop sign. We do admit or agree that the communication was confusing on how to handle the ticket, but no SOP violations were noted. So we're recommending no further investigation.
So moved.
Second.
Appreciate that. All those in favor?
Aye.
Thank you. Next, we're moving on to 183 IG-2025. The date of the incident was the 27th of November, and we received the complaint on the 1st of December. Complainant stated that we went to the AmVets Post 61 on Smyrna Parkway on Friday, November 27th, 2025. No one asked to see a membership card, ID, or even our names. We are 20 years old. Following a band, we had a blast, but they kept allowing non-members in there into the cantina, and I don't think that they were supposed to do that. There was no body camera or LMPD reports to report on this because there was no police activity. We're recommending no further investigation. We were able to review a complaint, and it revealed the following. The case did not involve police personnel from any jurisdiction. The complaint was with privately operated business serving non-member of club and serving minor alcoholic beverages. OIG found that no LMPD personnel were involved. OIG has no jurisdiction. However, we did refer the case to the Alcoholic Beverage Control.
Is this where it's appropriate to move to accept the report?
Yes, I'm sorry. I should follow up with, we're recommending no further investigation.
No, please note my motion.
Second motion for no further investigation.
Thank you.
Next is 187 IG-2025. The date of the incident was April 15th. We received the complaint on November 10th. Complainant raised concerns with violations of due process, dishonorable conduct, deprivation of constitutional rights, unnecessary force, and defamatory statements by LMPD. Complainant states LMPD officers pulled up behind her vehicle after her vehicle broke down in the center of the road. Officer told the complainant to attend her daughter, who had been moved to a family member's vehicle out of the roadway. Complainant alleges as she approached the other's vehicle, an officer stated, quote, "You can't leave," unquote. And the next thing the complainant knows, she's on the road with 13 officers on her. We were able to review the body-worn camera, the LMPD reports, the computer-aided dispatch reports. We reviewed policy 9.3. Other materials reviewed were the citation, CourtNet, and the use of force report. We're recommending no further investigation. After reviewing all available evidence, our office was unable to substantiate any violations of LMPD policy or violations of due process, dishonorable conduct, deprivation of constitutional rights, unnecessary force, and defamatory statements. Once the officers told the complainant she could not leave, the complainant told the officers no and began to resist officers. Complainant resisted officers to the point of kicking and attempting to bite the officers. Therefore, we're recommending no further investigation.
Move to accept that recommendation.
All those in favor?
Aye.
All right. I was all confused here. We changed forms. Next is 188 IG-2025. The incident date was the 6th of November. And we received the complaint on the 9th of November. It was an anonymous online complaint. On November 9, 2025, Office of Inspector General received an anonymous complaint regarding an encounter between Louisville Metro Police Department officers and a minor at a residence on Aspen Drive. Complainant alleges officers approached a juvenile with firearm drawn while he was working on his vehicle in a driveway of his residence and ordered him to the ground. Complainant further alleges that the juvenile's mother was detained when she exited the residence to determine what was occurring. In our preliminary report, we outline the timeline as it's documented on the body-worn camera. And then as it relates to the background of the police activity, on November 6, 2025, LMPD officers responded to a reported home invasion robbery at 9002 West Manslick Road. A description of the suspect and their vehicle was broadcast to responding officers. Detectives from the specialty unit later located a vehicle believed to be connected to the suspects and initiated surveillance. When officers attempted to follow the vehicle, the occupants exited and fled on foot. Officers began searching the surrounding neighborhood for the suspects, described as light-skinned black male and a heavy-set Hispanic male. Incident number 1, 17-year-old detained at gunpoint at 8315 Aspen Drive. Body-worn camera footage shows officers approaching the complainant's 17-year-old son while he was working on a vehicle in the driveway of his residence. Officers exited their vehicle with firearms drawn and ordered the juvenile to the ground. The juvenile complied with commands. Officers quickly determined the individual was not the suspect they were searching for and left the scene after approximately 53 seconds. During the encounter, the juvenile's mother exited the residence and asked officers what was occurring. Body-worn camera footage shows an officer grabbing the complainant by the arm and directing her away while stating, "Do not walk up there." Incident number 2, a 15-year-old takedown at 8301 Aspen Drive. An LMPD sergeant attempted to stop an individual later identified as Alejandro Perez Crista, a 15-year-old male who had recently exited a nearby school bus. The juvenile briefly ran before stopping. Officers took the individual to the ground and placed him in handcuffs before determining he was not the suspect being sought. This was a use of force report classified takedown as a level 2 reportable force due to minor injuries sustained during the encounter. There was also a search of the juvenile's backpack. Body-worn camera footage. Body-worn camera footage shows officers searching the juvenile's backpack. After he was detained and placed in handcuffs, the juvenile was not arrested, and officers had already determined that he was not the robbery suspect they were searching for. LMPD SOP 3.6 governing investigative stops and searches states that searches of personal property generally require consent, probable cause, or other legal justification. Investigators did not identify evidence indicating that consent was requested or granted prior to the search of the backpack. As a result, the search may be inconsistent with SOP 3.6. Potential SOP violations for these two stops relate to firearm pointing not documented as level 1 reportable force, detention of complainant during an investigative stop 3.6, plainclothes officers identification considerations 4.28.1, search of a juvenile backpack without documented consent 3.6, and Axon signal sign harm activation logging issue, which is 4.13.4. Based on this conclusion, we're making a recommendation that the Office of Inspector General refer this case for investigation by the PSU unit and that the OIG do no further investigation.
Motion, we accept the recommendation. Second.
Thank you.
IG-2025, the date of the incident was the 16th of August, and we received the complaint on the 23rd of October. Complaint alleged that on August 16th, 2025, her brother was involved in a domestic dispute with his ex-girlfriend and the mother of his child at their father's house. Complaint further alleges that members of LMPD did not charge the ex-girlfriend with the proper charges. We were able to review the body-worn camera, the LMPD reports, the computer-aided dispatch reports, and we were able to interview the complainant. The preliminary investigation revealed that on August 16, 2025, members of LMPD's 1st Division responded to a call for service for a domestic dispute between the complainant's brother, the victim, and his ex-girlfriend, the subject, regarding a custody dispute. When officers arrived on scene, the subject had left with her mother and father. Officers began interviewing the parties that were present and gathering information. The victim alleged that the subject entered through the back of the house into a bedroom that he was sleeping in and began assaulting him. The victim's sister, the complainant, mother, and father all got involved. Shortly after officers arrived on the scene, the subject returned with her mother and father, who were also involved in a physical altercation between the parties. When interviewing the subject, officers noted that she smelled like alcohol and appeared to be intoxicated. After interviewing all parties and reviewing video from inside the house, officers arrested the subject and charged her with assault 4th degree, domestic violence, no visible injury. Complainant alleged that members of LMPD did not properly charge the subject because she was not charged with breaking and entering. The complainant and her family were also upset that the subject's father was not arrested and charged with any offense. Officers explained that the subject's charges to the complainant and her family. Members of LMPD may only arrest and/or issue charges to an individual in which they have probable cause to support those charges. OIG staff determined that LMPD acted within policy. Therefore, OIG staff is recommending no full investigation.
Motion to approve recommendation.
Second.
All those in favor? Thank you.
And Ed, I'm right. All these people could have come down since this did not appear in the officer's presence. Each one of these individuals who have claimed that they were wrong or the police handled it wrong could have gone and sought a warrant themselves.
Yes.
Okay. And, maybe we need to throw that in just for others who are on the board that don't have a legal background, so that everybody knows. That's just one door was closed. There were other doors that they could have entered had they chosen to do so.
That's a good point. Yes. Excuse me. Next on the agenda is 192 IG-2025. Complaint alleges that her vehicles are being maliciously towed by ABC personnel. The vehicle towing was not done by or at the behest of LMPD officers. LMPD officers were drawn into this case when complainant had a midnight verbal dispute with tow lot personnel who refused to release the complainant's vehicle. Complaint was lodged with LMPD alleging they failed to complete a report on the matter as complainant was told at the time of the incident. This was a miscommunication from a momentarily unaccompanied probationary officer who did not articulate the difference between a report and a computer-aided dispatch record. 6th Division Commander took the complaint and they completed a not handled by PSU investigation into the complaint. The OIG finds the original issue with the vehicle is a civil matter and did not involve LMPD. LMPD officers on scene acted within policy. Regarding the complaint lodged with LMPD supervisory personnel conducted a fair and complete investigation and determined responding officers acted within policy. Therefore, we're recommending no further investigation.
Motion to approve.
Second.
All those in favor? Thank you.
Next, we move to 199 IG-2025. Preliminary report. Preliminary investigation. The Louisville Metro Office of Inspector General conducted a preliminary investigation into allegations of abuse of police authority involving an LMPD officer during a traffic stop that occurred on December 18, 2025, near St. Catherine and South 4th Street in Louisville, Kentucky. The investigation reviewed the body-worn camera footage, in-car video footage, the computer-aided dispatch records, and the uniform citation post-arrest complaint in order to reconstruct the incident and evaluate whether the arrest of the complainant for reckless or negligent operation under Kentucky Revised Statute 189.290 was supported by the observable evidence. Video evidence shows the complainant's vehicle entering the left lane briefly in order to pass a dump truck before returning to the right lane. The footage does not clearly show the complainant traveling left of center for an extended distance, nor does it document other vehicles honking or traffic conditions consistent with the, quote, moderate to heavy, unquote, traffic described in the officer's citation narrative. Additionally, the available video suggests that the complainant's vehicle was not within the officer's direct line of sight at the time some of the alleged driving behaviors were said to have occurred during the presence of a dump truck obstructing the officer's view. As a result, several factual assertions contained in the citation documentation are not corroborated by available video evidence. Body-worn footage further indicates that the encounter escalated rapidly, approximately 1 minute after the initial contact. The officer was heard telling another officer that the complainant was, quote, going to jail, unquote, and approximately 2 minutes later, the complainant was placed under arrest and transported to the Louisville Metro Department of Corrections. While Kentucky law permits warrantless arrests for violations of KRS 189.290 committed in an officer's presence, the evidence reviewed during this preliminary investigation raises questions regarding whether the complainant's driving behavior met the statutory threshold for reckless or negligent operation, and whether the facts documented in the citation accurately reflect the events captured on video. The central administrative issue was not solely whether legal authority for arrest existed, but whether the decision to effectuate a custodial arrest, the articulation of probable cause, and the accuracy of the official documentation were consistent with Louisville Metro Police Department policies governing enforcement discretion and reporting standards. Recommendation: based upon the available evidence, the Office of Inspector General recommends that the matter be referred to the Louisville Metro Police Department's command staff for an administrative review to determine whether the officer's actions report complied with departmental policy. The command staff should evaluate whether the arrest decision was supported by sufficient articulable facts, whether citation and release should have been a reasonable alternative enforcement action, and whether the documentation accurately reflects the events observable on video. Consideration must also be given to refer the matter to the early intervention program as a non-disciplinary mechanism to review potential decision-making or behavioral concerns. The Office of Inspector General makes no determination regarding criminal liability. The purpose of this recommendation is to assist LMPD in assessing policy compliance and ensuring that enforcement actions and official reports accurately reflect the facts supported by the physical evidence. So, based on a review of the available evidence and according to the camera footage, while KRS 431.005 permits a warrantless arrest for violations of Kentucky Revised Statute 189.290 committed in an officer's presence, the available video evidence raises concerns regarding whether the complainant's driving behavior met that threshold. Evidence suggests the complainant briefly entered the opposing lane to pass a dump truck and then returned to the passing lane with no clearly observable oncoming traffic or immediate hazard to others. Accordingly, it is recommended that this matter be referred to Louisville Metro Police Department command staff for an administrative review.
And just as a member to point out, we've now had, I don't know how many cases we've already reviewed. None of them so far has included a recommendation of anything other than what was suggested by you. I don't want to ever be cautious so we don't get the chief mad again and then stating that we are beyond our legal inquiry or inquiry, not legal inquiry. The issue here is there's nothing to support reasonable and articulable suspicion under the law for a stop of this type. Am I saying that correctly?
No, it's not the stop. It's the subsequent arrest of the driver and not the stop itself.
What was the citation? Because I just pulled it up. The statute, I guess he's being cited under is reckless driving, right? I mean,
right.
5 different subparts.
Yeah.
So, but I think what you were asking was, is that what he was actually arrested for, or was there some subsequent violation that occurred during the stop that he went to jail for?
I think both things are probably what I'm questioning. I'm also wondering, am I going too deep in the weeds when that's not really what you're asking us to do? about as non-damning as we could recommend, correct?
Yes, right.
But it is still under our purview that, hey, something doesn't add up right. We don't know what it is exactly. It's probably worth another look by you guys. Am I saying that correctly?
Yes. We think it's appropriate for the not handled by PSU designation that they have. They have the not handled by PSU, which is a lower level than the PSU, and then, of course, the PIU. So those are the levels of review that they have available at LMPD. And in this case, we're recommending the not handled by PSU review.
Okay. Well, then I would make a motion that we accept that recommendation. And I thank you for that clarification, because not all of us are like Scott, who have the experience and seen all sides of this issue from, all the different boards he served on. So that was helpful. Thank you.
Well, and this is still pretty actually new for everyone, because, just under the last 5 months or so, are we operating under the auspices of the community commitment, where in the past, we would have just said there would have been, if the complainant wanted us to do it and it fit our parameters, we'd do the investigation. And so we're working under those auspices of the community commitment. Under abuse of authority.
Okay. Well, again, I just renewed my motion. I think that's probably the level it should be looked at, unless others disagree. But it should be looked at again.
Are you saying hold off on the recommendation and consider to move it up a level?
No, sir, just the opposite. I apologize, I was not clear. I think the recommendation that Ed has made is the appropriate one.
Okay. No, appreciate that.
Is there, I guess I'm just kind of curious, it sounds like whatever the reason that he was pulled over, that maybe the interaction was the reason that he was arrested or taken to jail, rather than just written a citation for reckless driving. That kind of sounds like what it may be. So I'm curious, part of the investigation, it says 60 seconds after the interaction began, he's saying he was going to go to jail, and within another 2 minutes. Do we know what happened in that 60 seconds? I'm just curious there.
There was I believe it was a conversation between two police officers. And I don't know exactly the gist of that conversation. I think
it wasn't 60 seconds of the driver being uncooperative or hostile to the officer. Is that accurate?
That's probably a matter of interpretation by who the officer is and which officer you have. Mike, would be my thought, because for some that would be escalating conduct because they weren't immediately following exactly what the officer wanted to, and that's an issue and a problem. I don't think we have enough to go on, and somebody needs to look at it more closely as to why Ed made that recommendation.
Okay.
I think that's one of the aspects that would be reviewed by the commander.
Which, again, is appropriate for us to ask. And two,
it's the least outwardly damning thing that we could do without ignoring it. And this department is probably not, because of so many issues, we need to be careful. And I think this is an example of the board being careful. And I'll renew my motion.
So you need a second, I guess, for the motion, right?
If that's what you all want to do.
Anybody else have any thoughts?
Wow, sorry about that. I was trying to note that there's a message that's coming that says this is Chief Humphrey, and they can clarify why it's not being handled by the PSU process.
Well, we're just recommending that it not go through the PSU. That the chief could make a determination that it needs to be a PSU investigation once they receive the complaint. So the chief has the discretion to make whatever decision he chooses based upon what we present to him.
Noted. I can explain well, if we have a minute, then would you like for the chief to give you a clarification?
Well, I don't think we're asking for that to
No, we're not.
go to PSU, so it's unnecessary. If the chief wants to jump in, I want to, of course, hear anything the chief has to say. But I think this is just something that doesn't quite, we're without sufficient information to make a decision one way or the other. And we don't have immediate access to that information. And the party who does is the department itself. And we're saying, hey, you all probably need to take a look at this. And that's our recommendation. Ed, am I correct?
That's correct. That's all we're recommending.
And nobody should take offense to that because they probably haven't seen it themselves. And I don't think they are. Yeah.
All right, and I'll just give the chief I don't know if I'm able to unmute. Oh,
Okay, so
but
I see Jennifer Keeney as an attendee. Is that Chief Humphrey as well?
Yes, that is Chief Humphrey. Thank you for allowing me to speak up. I wasn't trying to make a recommendation on what you all should do. I was just trying to give some clarification on what the not handled by PSU process that the Inspector General was referring to looks like. That process is the equivalent of a PSU investigation. It's just not handled through PSU. It's handled at the division level through the major of that division. I think what we use those in types of investigations for things that we may not necessarily have to ask clarifying questions of the particular officer. And so I think what Inspector General Harness is looking for here is that we as a command staff review this incident and then make a determination whether this needs to be an actual investigation. So just for clarification on that process. At the end of a not handled by PSU investigation, it will be assigned a PSU number and there will be a finding that it goes along with it.
No, appreciate that. And so from my understanding, it's almost kind of like you guys do your high level review before you determine if it needs to be more granular or detailed.
Yes, sir.
Anyone else have any questions for Chief Humphrey? Appreciate you taking the time to clarify that.
So I guess we're back to our original, which was Ed's recommendation that we turn that over to the department and say, hi, folks, you might want to look at this and make decision what you all think we should be done.
Correct.
So Benham, if your motion is to agree with that recommendation, I'll second it.
Thank you.
All those in favor? Thank you.
Next on the agenda is 200 IG-2026. Complainant alleges that on December 16, 2025, home incarceration program officers entered her residence and detained her boyfriend who was on home incarceration. Complainant further alleged that the HIP officers detained her 13 and 17-year-old children for an extended period of time before releasing them. We were able to interview the complainant and witnesses in this matter. The preliminary investigation revealed that the complainant's boyfriend was on home incarceration and living in her residence. On December 15, 2025, around 9:30 p.m., HIP officers arrived at the complainant's residence. Complainant's children, 13 and 17 years old, were placed in handcuffs, and the complainant's boyfriend was returned to Louisville Metro Jail. Complainant's children were released. OIG staff requested information from LMPD to determine if members of LMPD were involved in the incident. A review of the Jefferson County Sheriff Office computer-aided dispatch showed a Jefferson County Corrections Officer, Unit S927, was on the run to the location at on December 15, 2025, around 9:30 p.m. LMPD was requested for backup at 9:42, but then canceled at 9:43. Per the computer-aided dispatch report, LMPD never responded. OIG does not have jurisdiction to investigate complaints against Louisville Metro Department of Corrections employees or corrections officers. OIG staff did provide the complainant with the Louisville Metro Department of Corrections online complaint form and telephone number. Therefore, OIG staff is recommending no full investigation.
Motion to approve. Recommendation.
Second.
All those in favor? Thank you.
(205 IG-2026). Complainant states they have reported harassment and assaults to LMPD, only to have LMPD not listen to their reports. Date and location of incidents is unknown. Following multiple attempts to contact the complainant via phone, email, and mail, snail mail, I should say, our office was never able to establish contact. Without a date and location, it is impossible to move forward on the investigation. Therefore, we are recommending no further investigation.
And Ed, just for the public to know, if they're reviewing this, your office documents the attempts. We can see the email was sent and delivered and all those kind of steps, correct?
Correct.
Okay. I'll renew the motion to approve the recommendation.
Second.
All those in favor? Thank you.
206 IG-2026. Complainant alleges that on October 11, 2025, her brother was killed. Complainant further alleges that LMPD has failed to properly investigate the incident. We were able to interview the complainant in this matter. Preliminary investigation revealed that the complainant's brother was killed on October 11, 2025 in his home, located at 3626 Garland Avenue. OIG staff interviewed the complainant. Complainant stated that in her interview that no one from LMPD has contacted her and she has information related to the incident. OIG staff contacted LMPD and was informed that the homicide unit assigns one family contact person and that as the only person they provide information to, but explained that the complainant could contact the homicide unit and provide any information she has. OIG staff informed the complainant of the homicide unit's process and provided the complainant with the homicide unit's contact information. Complainant had no further issues. Therefore, OIG staff is recommending no full investigation.
Motion to approve recommendation.
All those in favor? Thank you.
207 IG-2026. Complainant states that they called Metro Safe requesting LMPD send officers to assist her with retrieving a vehicle registered to her friend from a boyfriend with whom she had an active EPO against her former boyfriend. Complainant alleges responding officers were rude and denied her a police report. Complainant also alleges that the officers themselves violated the EPO. We were able to review the body-worn camera in this matter. Our office was unable to identify any SOP violations in this encounter, so we're recommending no further investigation.
How did the officers violate the EPO? Well, I didn't understand that allegation.
We were not able to interview the complainant in this matter after we received the initial complaint. So we're not sure how the department could have violated the EPO. It's not apparent on its face.
Thank you, sir. Motion to approve your recommendation.
Second.
All those in favor? Thank you.
208 IG-2026. Complainant alleged that in 2021, members of LMPD began investigating him and hiring unknown females to approach him, gather information, and report back to LMPD. Prior to the completion of the preliminary investigation, the complainant requested to withdraw the complaint. Therefore, the staff is recommending no full investigation.
Motion to approve.
Second.
So moved. Thank you.
210 IG-2026. Complaint was filed anonymously and did not include an incident date for fear that it would compromise their anonymous status. Complaint alleged that an employee at the Dixie Highway WIC office was unprofessional, disrespectful, and mean to the client. Complaint did not involve any member of LMPD. The preliminary investigation revealed that the complaint did not involve any members of LMPD, only an employee of the Dixie Highway WIC program. The Dixie Highway WIC office is the special supplemental nutrition program for women, infants, and children. They are not affiliated or a part of LMPD. OIG does not have jurisdiction to investigate complaints against WIC. Therefore, OIG staff is recommending no full investigation.
Motion to approve recommendation.
Second.
All those in favor? So moved. Thank you.
211 IG-2026. Complainant states there was a murder and they were arrested, but they did not do it. following multiple attempts to contact the complainant, our office was unable to establish contact with the complainant. So we're recommending no further or full investigation.
Motion to approve?
If I can just ask, before we do that, if someone is arrested, then how does the follow-up inquiry take place? I guess, Inspector Harness, that's what I'm asking as part of the follow-up, and I understand we're going to probably dismiss this just for my.
The complaint did not come from a detention facility. The complaint came from an outside line, and we attempted to contact through the information provided.
See, I question there.
It didn't come from. I mean, we do on occasion get mail and complaints from a correctional facility or from a jail, and it did not come through those sources. So.
Was there a name associated with it when the complaint was made?
I would have to check with the investigator on that.
I guess what I'm saying is that maybe they did call from an outside line, maybe their mobile phone during something. I guess I'm just wanting to make sure that we're not, and again, it's not really in relation to this complaint necessarily as much as just, anything. If somebody makes a complaint and then are arrested and are detained, I'm just curious as to what steps we take to make sure that they're actually contacted if they're incarcerated at the time. This is part of the follow-up investigation.
So I guess the question would be, is the first step of them making the complaint? That's where I'm sorry. I question you assume that they're setting this as like in first person. So they're saying this is a past tense, like a murder was committed. I've been arrested. All right. How did you send in this complaint? Did someone else put it in? And in the fill out form, they did put a contact information. So they went through all this process to do all that. And then you put in the contact information. If you are fearful for those aspects, it kind of already dissolves itself if you're asking those questions. So to your point, it's like, all right, did they think to go online, look up this form, fill it all out, and then they were arrested? Or how does all of that play out? Is the concerns I'm thinking of, if that makes sense.
Well, if we do get information from a jail's, with a mail address to the jail, we do mail the jail and try to contact the inmate. We have gone to detention facilities and interviewed complainants. So we do the best to follow up with the information provided to meet with, discuss the incident with the complainant. It just doesn't appear that there was anything that we could minimally substantiate anything regarding a murder arrest related to this particular complaint.
And part of me would recall that previous finding where there was a situation where someone was wrongfully jailed and there was an administrative error, but there was, I'm assuming there was kind of contact or communication with their attorney or other aspects for that.
In that particular case, the complainant came to our office directly.
But that was after he was released, right? Obviously. I guess.
That's correct, yes. Yeah.
Well, again, my question wasn't really directed at this particular fact pattern because I don't know what's in the complaint that we could really do much with anyway. even if they were contacted and just said I was arrested, but didn't do it. There's nothing more than that. It was more of a follow-up on what steps do we take to try and establish contact given different circumstances, including whether or not someone might be incarcerated at the time that the complaint is being reviewed. It was more just a general question. So, Benham, did you make a motion to accept?
If I didn't, I will, because there doesn't appear to be any
there for us to do anything.
Yeah.
So,
yeah.
All right, I'll second it.
thank you.
So moved. Thank you.
Thank you. 219 IG-2026. Last on our agenda. Complainant state they purchased a motorcycle from LMPD impound auction August of 2025. The VIN number was entered into the system incorrectly. Therefore, the correct lien holder was never contacted, leading to the complainant not being able to obtain a title. LMPD tow lot is not within our scope. However, we did forward this complaint to LMPD tow lot supervisors. I will add that Investigator Snow arranged to meet with Major McGahee regarding other types of complaints that I think even today we've had 2 or 3 that involve the tow lot, to facilitate communication between us and them to try and resolve these issues, for customer satisfaction. And we were sorry. And then that meeting was set up, but then it was canceled because the department has decided that they want to adhere to their strict protocol of communicating only through Major Wampler unless we have issued a 48-hour notice or a 7-day witness notice to talk with members of LMPD. So, I'm sorry, I didn't. So we're recommending no further investigation regarding 219 IG 2026.
Motion to accept recommendation.
All those in favor? So moved. Thank you. All right, I think that is all, and then next
That is all of those.
findings.
Next, we move to our investigative review of an officer-involved shooting, and the OIG case number for that is 138 IG-2025. And you've been provided a copy of this written report from the office. Officers responded to a trouble call at 3301 Atterburn Avenue regarding a male subject who was yelling at residents. Officers were alerted to the male subject now attempting to break the windows out of an apartment. Officers arrived on the scene and located the subject in a grassy area outside of a residence. Officers stated that they observed a knife in the subject's pocket. Both officers issued verbal commands to the subject, instructing the subject to not reach for the weapon. At this time, the subject started to walk away from them. Both officers attempted to detain the subject The officer resisted and they took the subject to the ground. On the ground, the subject was able to retrieve the knife and proceeded to stab one of the officers in the torso and the chest. During this time, one of the officers deployed their taser into the subject's abdomen. The probes were ineffective. One officer then transitioned to his duty pistol and fired one shot, striking the subject in the head. Officers performed CPR on the subject until EMS arrived. The subject was transported to Louisville Hospital, where he was pronounced deceased. In the evidence reviewed here were the two officers' body-worn cameras. We also reviewed the PSU case 25-02, which exonerated the officer for the incident, for de-escalation, for the use of electronic weapon, and for the use of deadly force. The Louisville Office of Inspector General completed a review of the officer-involved shooting, including an analysis of the investigative materials from the PIU unit, the Professional Standards Unit, the Performance Review Board, applicable Louisville Metro Police Department standard operating procedures, and relevant witness and officer statements. Based on a totality of the evidence review, the OIG finds that the actions of the officers during the April 20th, 2025 incident were consistent with LMPD policies and the laws governing self-protection and the protection of others. The evidence demonstrates that the subject engaged in active and violent aggression by producing a knife and stabbing an officer during a physical struggle. The other officer's use of deadly force occurred only after less lethal options were attempted and proved ineffective, and while an imminent threat of serious physical injury or death existed. As such, the use of force was objectively reasonable under the circumstances and consistent with LMPD standard operating procedures and applicable Kentucky law. While OIG occurs with the ultimate findings that no policy violations occurred related to the use of force, this investigation identified several areas of concern related to the untruthfulness of the officers, related to the lawfulness of the officers' actions. Those concerns include delays in the administrative review process within the Professional Standards Unit, inconsistencies with timelines, expectations outlined in policy, and statements made by involved officers during administrative reviews that reflect a misunderstanding of de-escalation principles as defined by LMPD policy. Additionally, the OIG identified procedural and governance concerns related to Performance Review Board process. Specifically, the PRB memorandum failed to include a synopsis of the observations of voting and non-voting members as required by SOP 2.34.8, did not articulate supporting rationale for its recommendations, and was not submitted within the policy mandated timeframe. The dual role of the Deputy Chief of Police serving simultaneously as the PRB Executive Committee Chair raises additional concerns regarding role clarity, potential conflicts within the advisory structure as outlined in the policy. The attendance of an actively assigned PIU detective at the PRB also raises questions regarding the separation of investigative and review functions. In conclusion, while this incident does not warrant further review regarding the involved officers' use of force, it highlights systemic and administrative issues that impact transparency, accountability, and public confidence. These issues warrant consideration by LMPD leadership to ensure adherence to established policies, reinforce accurate understanding of de-escalation principles, and strengthen the integrity and effectiveness of post-incident review processes. Based upon the findings of this investigation, the Louisville Office of Inspector General makes the following recommendations. These recommendations are intended to provide procedural compliance, training clarity, and administrative accountability issues identified during the review of 138 IG-2025 and do not suggest misconduct by the individual officers. Professional Standards Unit timeliness. PSU should ensure administrative investigations are reviewed and forwarded through the chain of command without unnecessary delay, consistent with the intent of timely and thorough investigations as outlined in SOP 1.9, which emphasizes completing investigations in a manner that engenders public trust. Delays identified in this case warrant corrective administrative review. 2, when extended review periods occur, supervisory personnel should document the justification for delays, consistent with accountability expectations inherent in SOP 1.9.2 and supervisory oversight principles as outlined throughout the policy. De-escalation training and policy understanding. 3, LMPD should reinforce de-escalation training consistent with the definition and requirements set forth in SOP 9.1.3, emphasizing that de-escalation is an active process involving communication, tactics, distance, and decision-making, not solely officer presence. Statements made during PSU interviews demonstrate a potential misunderstanding of this policy requirement. Scenario-based training Number 4, scenario-based training should include articulation of de-escalation efforts under rapidly evolving circumstances, consistent with SOP 9.1.1, use of force policy, to ensure officers can clearly explain de-escalation techniques or attempts, even when time or subject behavior limits available options. Performance Review Board compliance and governance. Number 5, PRB memorandums should fully comply with documentation requirements in SOP 2.34.8, including a synopsis of the observations of both voting and non-voting members and a clear explanation supporting each recommendation. The absence of documented observations in PRB 225.05 is inconsistent with policy requirements. Number 6, PRB submission timelines must be enforced in accordance with SOP 2.34.8, which requires submission of the PRB memorandum to the Deputy Chief of Police / Chief of Staff within 14 days of the review unless a documented extension is filed. Number 7, LMPD should review PRB governance structure to ensure compliance with 2.34.1 and SOP 2.34.7, particularly regarding the advisory role of the PRB to the Deputy Chief of Police / Chief of Staff, and need to avoid actual or perceived conflicts arising from the overlapping roles. Number 8, conflict of interest safeguards outlined in 2.34.6 should be reinforced, including clear guidance regarding attendance or participation by personnel actively assigned to investigate the incident under the PRB review. Next, supervisory and training development. Number 9, LMPD should implement PRB recommended updates to the acting sergeant course consistent with supervisory responsibilities outlined in 2.3.4 and SOP 8.1.2 responsibilities of commanding officers, ensuring supervisors are adequately trained in post-critical incident management and peer support team utilization. 10, periodic refresher training for acting and permanent supervisors should be implemented to reinforce compliance with SOP 8.1.2 critical incidents, SOP 2.5 administrative leave / administrative reassignments, and PRB related responsibilities under SOP 2.34, ensuring consistent application of policy following critical incidents. That concludes our review of this particular incident on, excuse me. IG-2025.
Any comments?
I mean, you're not asking, we don't have any role here other than you're reporting it to us, right?
Right.
Yeah.
And these are recommendations that will be forwarded to the chief tomorrow.
Can you explain sort of a very basic level of what was the concern over the conflict of interest? Because I'm not sure. Like what was the conflict of interest concern here, I guess, in terms of personnel?
In terms of the personnel, well, the way we look at the policy, you've got one person serving dual roles.
Okay.
And in this particular case, there was what appeared to be early involvement of the PIU unit prior to the PIU unit's conclusion of the actual investigation.
So if I'm understanding, it's like within the dual roles creates a conflict of segregation of duties, and it almost causes an overlap of the procedures or like the approval process or review process.
Not necessarily an overlap, but essentially you've got a person reporting to the same person, the way the roles are outlined. And it prevents a diversity of thought. Any other questions regarding 138?
I'll ask, what was the misunderstanding on the de-escalation?
In the interview, the officer outlined that officer presence was a de-escalation technique, and that was the de-escalation attempt. Simply the fact that the officer being on the scene, as opposed to active de-escalation, communication, space, time, those kinds of other active de-escalation techniques.
There used to be CIT training in our department. In fact, I think my wife was involved from the very first beginning. It was based out of, I believe, Memphis. They had certain dealing with people with mental illnesses. Is that still part of the training today? Are there still certified crisis intervention team members? Do they review these kind of shootings? Do they and provide input, or do you know?
I believe, well, there is the basic, I think it's 40 hours at the academy, and all officers receive that training.
Is there follow-up training yearly on that, or being offered?
I don't know how often it's provided as in service. And I do believe that the CIT expert, I think it's a sergeant at this point, maybe lieutenant, can participate in the PRB and may have a seat. I'd have to go back and look exactly at all the seats on the PRB.
Just want to say, Chief Humphrey put in the notes, confirmed to what Ed said. All MLMPD officers do receive CIT training courses.
And good. I'm glad that's still going on. It would be helpful to me and I think the committee to know, how often is this de-escalation training being offered? Is there a mandatory number of hours, within a 2-year window? Because face it, I mean, just the materials our officers receive that they're supposed to review and understand is significant. Are we allocating enough time, resources, man and women power to review a full understanding and testing and updating of this material?
I would just make a distinction of de-escalation and CIT, because those are two separate training tracks.
That complement each other.
They do complement each other. Yes.
And I can see why you did that. Okay.
And yeah, I don't know exactly what how often it's offered as the in-service, and we'd have to look at the curriculum as far as related to de-escalation out at the academy. But we could.
Well, going back to the Justice Department involvement, if I'm not mistaken, and it's been over a year since I've read those materials, there was criticism about de-escalation, and there was some concern, I thought, about mental health, as there are with all departments. I do not think Louisville at all is unique in this. Could I request that this board be provided this information, Ed, so we know? Because I think that would be a question that in the community we should be able to answer, and I can't answer that.
If you do, I just got a note that Chief Humphrey can answer that if you want clarification on that right now.
That he cannot answer.
He can.
He can. Okay. I would love to have any information, because I don't think this is the first time I've even raised this issue. I think I've mentioned it before. Sure. It'd be terrific.
If you're still on, okay, there you go.
Okay, I think I just unmuted. Yep.
Thank you. Yeah, so on the basic level, we do provide the CIT training course that you referred to earlier, sir. And we do have some sort of de-escalation decision-making training pretty much every year as part of in-service. And if the board would like, I can send you the curriculum for this year's in-service, where we talk about command and control issues as per the recommendations of both the PRB and the OIG.
I just think that's something we all should know.
Okay, I can send that to the board.
Your willingness to give that to us. Thank you.
Yes, sir.
Go ahead, Sims.
And where are we now? Is there
any other questions regarding 138 IG 2025?
I just had do we know the condition of the officer or chaplain?
I don't know. Let me see. Is the chief there? He can probably answer that off the top of his head. Is the officer recovered?
Chappell was actually stabbed in the vest. I think it was twice, and it did not penetrate his body armor, so he ultimately was uninjured. And both he and Officer Klingenfuss have returned to full duty.
Appreciate that clarification.
Thank you.
With that, I think we're good to go to 139.
Okay, 139 IG 2025. This incident took place on the 26th of April, 2025, 1614 Lincoln Avenue. It involved one LMPD sergeant, and it was a non-fatal officer-involved shooting. On Saturday, April 26th, at approximately 10:30, 7 officers were dispatched to 1614 Lincoln Avenue on a report of a subject threatening suicide, shooting a gun into the floor of the residence, and the caller was the subject's daughter. Officers arrived on the scene at approximately 10:45, and when they arrived, the subject was in the driver's seat of a vehicle parked in the driveway of the residence. The subject exited the vehicle with a gun in his hand and pointed it at his head. Officers immediately began attempting to de-escalate the situation. Officers requested less lethal backup, retreated away from the subject, dimmed their lights, and offered the subject help. While officers were attempting to de-escalate the situation, the subject in the driveway, LMPD sergeant began moving around the front of the side of the residence to find a different vantage point. When he was unable to do so, he contacted MetroSafe to determine if anyone was in the residence. MetroSafe notified him that there were 2 women inside the residence and they were in contact with the caller. LMPD sergeant asked MetroSafe to have the women come to the front door. The 2 women, the mother and a mother's friend, came to the front door and exited the residence. As they were exiting the residence, the mother notified the LMPD sergeant that her daughter was still in the residence. LMPD sergeant entered the residence through the front door to locate the daughter. Home video footage shows the daughter hiding in the dining room kitchen area. The subject then entered the home through the back door. When the subject saw the LMPD sergeant, he raised his gun in his hand and pointed it at the sergeant. The LMPD sergeant fired 1 shot and hit the subject in the arm, knocking the gun out of his hand. Officers retrieved the gun and immediately started first aid. The subject was transported to the hospital and charged with wanton endangerment 1st degree against a police officer. On April 28th, Chief Humphrey initiated a PSU investigation. On October 13th, 2025, the completed PIU preliminary findings and conclusions report was forwarded to the command staff for review. On December 4th, the chief notified the sergeant that he was exonerated of any policy violations related to LMPD SOP 9.13, de-escalation, use of force, and LMPD SOP 9.18, use of deadly force. On December 11th, 2025, the PSU file was forwarded to OIG for review. Through the review of the body-worn camera evidence, it is apparent that the LMPD sergeant utilized several de-escalation techniques prior to his use of force. Through the review of the body-worn camera, you can clearly see that the subject entering the back of the house and raising his gun and pointing it in the direction of the LMPD sergeant. The LMPD sergeant only used deadly force when the subject posed an imminent threat of death or serious physical injury, not only to the LMPD sergeant, but his daughter also, who was hiding in the house. The evidence clearly supports an exonerated finding of any LMPD violation. OIG staff found the PSU investigation to be complete and thorough. The PSU investigation substantially met the operational and procedural standards set forth by LMPD SOP. The report demonstrates appropriate investigative methodology, factual corroboration, and policy citation. OIG has no further OIG has no recommendations regarding this matter.
Motion to accept the recommendation.
Vote on this, do we?
No, I'm sorry.
Hey, you're good. It's just purely informational,
Yeah.
but any other comments?
Any other comments?
I would comment that probably the discretion used by Officer Pedigo to shoot the subject in the arm rather than making a lethal shot.
I
seem to be of his, maybe something that decreased his own personal safety, right? So seems like to me,
I don't think they made that. Mike, I don't think they make that kind of decision. When they shoot, they're shooting to center mass. That's just where he got wounded, which is fortunate for everybody.
Yeah.
Would be my most likely what resulted in. Ed, am I right about that?
That's the training, yes.
well, not taking a second shot that is center mass, I guess, at least.
Not
is satisfied that the fellow's incapacitated at that time is, I guess I'm just saying I would commend the officer's actions here.
Agreed.
Comments?
Chief Humphrey also noted that he could clarify about the choice to shoot in the arm.
Please.
Sure.
All right, let me get over there. Get the mute and okay.
So to Mr. Harness's point, we do not teach people to shoot in the arm. It's hard enough to shoot people in any part of their body. I believe Sergeant Pedigo expressed that was the only targeting area available to him at the time. And we were just all very fortunate, including the suspect involved in this case. And just as a follow-up, what you said of him making a decision not to fire a second shot, it's something that we do talk about in training often, not just with shooting, but with any uses of force, that every subsequent use of force is its own decision. And so you have to process that based on the circumstances at that time. So fortunately, these circumstances changed and he no longer had the gun and we could deal with first aid. But the decision for him to go in that house in order to make sure he protected the other people that were still in the house, as opposed to turning this into a barricade with SWAT or something like that, very possibly saved his life and the life of some of his family members.
Agreed. Thank you for that.
Has the officer received the accommodation regarding this matter?
Yes, he actually received an award just at our awards ceremony just a few weeks ago.
Okay, great. Any other questions regarding 139? Okay, that brings us to, I'm sorry.
1 second, Ed. I was going to say, before we start that, there was a comment from Chief Humphrey again regarding all the way back to the tow lot finding. And
oh, okay.
Clear up, but I want to give a second to create clarification, or give him a chance to create clarification on that.
Okay, let me go back and unmute.
Yeah, so this was less about the tow lot issue specifically and more about direct access to our employees and the comments that Mr. Harness said. I sent an email to you yesterday, Mr. Harness, trying to make sure we work that out so that you get access to informational people directly when it's possible. But I think that chain may not have gotten to you yet. But the whole point of being able to go through and make sure that the command staff knows what's going on is exactly the problem with what's going on in the tow lot. It sounds like is that your investigators reached out to an employee at the tow lot directly multiple times who hasn't handled the problem yet. As a command staff, we were never made aware of the problems that you were receiving, and so we want to make sure that we get those out to you. So I sent you an email. Maybe you can we can talk about how to collaborate better and make sure that you do get the informational access and your people get the informational access that they need. But we're also made aware of the issues that you're finding. And that was a follow-up based on our meeting from 2 weeks ago.
Yeah, Chief, I got that, and we were having a staff discussion, partial staff discussion regarding it today. So I'll get back to you with that. Thank you.
Follow-up question, if you don't mind, Chief Humphrey. For this communication breakdown, and so I can help further for us, for board members, are you wanting us, is the goal for the board to also align with this communication structure with the OIG, or are you wanting a different one when contacting you guys, especially your command staff? So, for example, us contacting about training and whatnot, we're going to Major Wampler, but do we need to CC certain folks, or if we have more questions before our board meetings, do you want us to contact you, Deputy Chief McKinley, or whatnot?
Well, I think you all just going directly to Major Wampler is sufficient. What I was trying to do was kind of bifurcate, since Major Wampler handles investigations and whatnot. I was trying to give the option for the OIG's office to be able to go to someone different, so that we have a differentiation between informational inquiries. Because I agree with Inspector Harness that there are often times that they just need information, or they need to get information to us, and there needs to be a more efficient way of doing that than constantly going through Major Wampler. And so that's why I asked for that to be the way that it is. But I think you all are fine to go directly through Wampler, and he can filter it wherever it needs to go.
And yeah, our request will be purely informational aside from OIG. So.
Okay. But if you want to copy DC McKinley, that would be good.
Will do. Thank you. I think that was all. Appreciate you joining us, Dr. Dickey. I think we can go on to Chief's responses.
Yes, you've been provided Chief's responses for two cases, 197 IG 2025. In 197, the Chief outlines the review conducted and findings related to the officer.
I would ask if Major Wampler could provide for us a suitable for public viewing copy of the body recorded camera for this incident, so that the board can review that in the context of the Chief's response. And so I would ask that we bring this particular response back, and then in that time, I can get a determination whether or not Major Wampler can provide that to us.
We can facilitate that, sir.
Great, thank you. And so then on to 201 IG 2026, based upon the recommendation, the chief has initiated a PSU investigation, and upon its completion, we will receive a copy of the investigation file. So that concludes that. Moving on to other business. As the chief pointed out, we did meet a couple of weeks ago, and we had a meeting. I think it was a productive meeting, and we briefly discussed the MOU recommendation from the board. The chief and his staff had not had a chance to do a full review of that. And as you could hear from the discussion today, we did discuss access to information and personnel, so that we can provide, from our side, we want to be able to provide the citizenry, better answers. And sometimes that can be just done with a direct phone call to someone at LMPD to answer a question or to informally resolve a problem. And as I pointed out to the chief, that we understand what our responsibilities are, that if we are doing an investigation, that we have to issue a 48-hour notice for a target and a 7-day notice for a witness. And if those haven't been issued, then our conversations would not be a part of an investigation. We also discussed, I provided a brief summary of LMPD's obligations under the community commitment, with the annotated paragraphs from the community commitment. I provided that to the chief at the meeting, so he just had the ability to do a cursory review of that. We discussed the training for the board members, trying to establish a date late May, early June for the training at the academy, and that the possibility of that training then being recorded for future use, so that the training can be more easily accessible as we have board member turnover. Some of it can't be virtual, the actual use of the firearm simulation trainer, discussion of some of the hands-on techniques that the officers have to use, so those things. But I think we could very easily take it from a two-week training at the academy to a 1-week training at the academy in person, and then the other be virtual. So we hope to have that available and ready end of May, June, to allow everyone and the officers to get through Derby and all of those obligations. We also discussed a strategy for having the OIG, officer involved shooting, findings presented to the performance review board, and how we could work that out tactically so that our information gets there, so that we could have a discussion of our findings, that our findings would not change as publicly reported, but that our discussions could inform future reviews as we move forward, so that both entities could learn from each other. We also asked for 30 to 45 minutes at the academy for all of the cadets, so that we could introduce the Office of Inspector General, the Civilian Review and Accountability Board, and give an overview of what our function is. And then lastly, I think we agreed that we're going to try to meet on a more regular basis, trying to work that in conjunction with the Civilian Review and Accountability Board meeting, so that maybe we can have the Civilian Review and Accountability meeting on a Tuesday, and then we meet on a Thursday to discuss the results of that meeting and any recommendations that come from the meeting, and any other investigative files and things that need to be turned over at that. So I thought it was a productive meeting, and that's my report on the meeting with the chief. And that is all I have at this point.
And I thought there was a discussion at one time, and it may have been 2 or 3 meetings ago, about stats with regard to, I don't know if the public is aware of the volume and the number of issues that come before this board. And I think they would be somewhat comforted to know that many of the things that come before this board, and I used the phrase earlier today, there's no there, meaning because of insufficient cooperation from the people who were reporting problems. I'm finding it as a new member, we are constantly basically following the recommendation that has been most notably given to us, that we should approve of what happened and they're doing good, just to reinforce to the community that there's improvement here. And I think there's improvement even since I started being a member here, as far as speed of getting these cases processed. And I think that's positive things that reflect positively on the department, and should reflect positively on your work too.
Did want to speak a little bit to that, but that's if Ed had anything else. These are going to be my last final thoughts before we adjourn. Did you have anything, Ed, before I start?
Me? No, I didn't. Or Ed?
No, we are recategorizing the quarterly report that we present to the public and to Mayor and Metro Council, which will be at the next board meeting for approval, which we, so maybe that will do a better job of painting the picture.
Yes, sir. Great.
Appreciate that, Ed. I did want to note, before we adjourn, everyone's winding down for the day, but I did want to thank Denise and Scott, because I know you guys do roll off exactly tomorrow. So I appreciate you guys even just attending this as your last board meeting. For context, for our new members, Scott and Denise have been here for the original board. I only came in here 2 years ago, so they've been along the way with Ed and the OIG staff. So overall, it's been a bumpy ride, but I really do appreciate you guys and everything that you guys have done. And this kind of officially marks off where it's a new transition for the crab, where it's a whole new, clean new slate, but we do have to pick up from where you guys left off. So I hope we do have the opportunity to show and reflect a lot of the hard work that you guys have done. So just wanted to say thank you.
Yes, thank you very much.
Thanks, Joel. It's been an honor to serve. I'm proud of this board and of the Office of the Inspector General. I really appreciate the significant progress in establishing a more cooperative and collaborative relationship with LMPD leadership. which I think is evidenced in this meeting today by their leadership participation. I'm confident that the board and the OIG are on a good track, and I look forward to seeing from the sidelines reports of its continued important good work. So thanks.
Yeah, I echo everything that Scott said. It's been an interesting journey, but I do see tremendous progress. It's one of the reasons I got involved in the first place was to foster good relations between the community and LMPD. So congrats to everybody, to Chief Humphrey, Inspector General Harness and the team, and all the members of the board. I think we've made a lot of progress.
With that note, I want to, for the outcomes and expectations or goals that I want for this year going forward, is that to a lot of the things that you've talked about, Benham, is that it does take a lot of onus on us as a board to kind of help support a lot of the work that Ed and the OIG staff is doing. So, for example, I'm going to try to encourage us to kind of go through the MOU bylaws, as well as making sure that we are consistently contacting like Major Wampler to make sure that we can get those ride-alongs going on. So I have my first one next month, but especially with helping specifically with community engagement, and not only just the community, the public, Metro Council, but also the mayor's office. I mean, going out there and just introducing. I know you guys are out there in a lot of networking. I'm still going into a lot of spaces where I have to tell people I'm the board chair, which is an uncomfortable thing to say, but also it sucks that I've been on the board for 2 years and it's still not, I still have to reintroduce those stuff, or people are still like, wait, oh, I thought that was canceled. So the onus on us is to challenge not only making sure we're creating that awareness, but also challenging Metro Council and the mayor's office to create that awareness. Because once Ed and his staff brings out that quarterly report to them, are they making sure that's going out to their districts? Are they making sure that we are seeing the progress that's being made? Are they noting that there is communication and collaboration happening with LMPD and the OIG? Are they noting where they see that there's areas for opportunities? So the biggest aspect that we do have in our power is consultation. So no matter what, we're already doing that with OIG, with LMPD. How do we do that with Metro Council as well as the mayor's office? So everything I'm asking you guys to do is not something that I'm not going to do. So I already have a couple of meetings with Metro Council, with House representatives, and the goal is to try to get some with LMPD as well as the mayor's office, but even our local organizations, because a lot came and showed out for Ed when the vote came to do the reappointment. So we need to be heard out there, but we also need to hear the voices of the citizens and public. So that is my spiel. Appreciate you guys. You'll see a slur of emails come out from me, but if there's any questions or concerns, reach out to me or Ed, and then we can go from there. But if there is nothing else, I'd like to call this meeting to an adjourn. And I believe our next one is April 28th. Are we in person or?
Typically, this would be an in-person. If you have a suggested location, that would be great. We could try and set it up.
I do have a couple of options. I need to double check.
Okay.
And I'll reach out to you then.
Okay. Sounds good.
Scott, really good work that you've done over your career. Thank you.
Awesome.
All right. Thanks, everybody. Be safe.
See you guys.
The people of Louisville deserve a mayor that will listen, that will offer opportunity, that will make sure the most marginalized get the resources they need. I'm here to tell you that I am the right choice because I've been working for you the whole time. I plan to be exactly who I campaigned to be. And every role I've taken in this city has been to serve and take care of people. On May 19th, this is too important for you to stay home. We need you to go vote for your future. Louisville, it is our chance to change the direction and to make it better. Louisville is better when we come together as community. Louisville, it's time.
This is brought to you by the people to elect Shamika Parrish Wright.